So I'm here with partner attorney Flomy Diza. Hello, sir. How are you?
I'm good, Troy. Pleased to meet you.
All right. Thank you. I just want to ask you a ton of questions, especially about the K visa. I really want to know what exactly is the K visa.
A K1 is a popular visa which is a quick way to bring a fiancé to the United States, usually within 6 months. But if it's not done right, it can delay the case for years. The basic requirements are that the petitioner and fiancé have actually met within the past 2 years, that they both have the capacity to marry, absence of certain types of criminal convictions, and a bona fide intention to marry within 90 days. The legal requirements appear simple enough, but because of the high incidence of fraud, K1 visas are closely scrutinized at 2 different levels. First, at the Immigration Service, and secondly, at the U.S. Embassy where the K visa will be issued. Some problem areas are age differences, financial inability, criminal convictions, issues that may arise during the medical examination, insufficient proof of the relationship, and, most commonly, failure to properly document the application both at the Immigration Service and the U.S. Embassy.
What are some of the things at Reeves and Associates that you do to help prepare someone go through this process?
Oh, that's a very good question, Troy. Well, first, we spend all the time necessary in order to qualify the petitioner and beneficiary for the K visa. This is done for both in-person and by telephonic conferences. Both the attorney and the support staff work closely with the petitioner and the fiancé. As previously mentioned, K visas are closely scrutinized at USCIS in the United States and at the embassy. The staff at the Manila office will prepare additional documents to be presented at the embassy. In addition, our U.S. attorney will meet with the fiancé in the Philippines through our audio-televideo conferencing hookup. We see the fiancé in a widescreen high-definition TV, and the fiancé will also see us the same way in a face-to-face meeting. It is very important just how the fiancé will present him or herself at the embassy and be able to answer the questions.
Okay, what do you think are the strengths that Reeves and Associates have over, let's say, some other law firms that are handling these type of visas?
At Reeves and Associates, we personally meet with each and every one of our clients. We interview our clients either in the office or by televideo to prepare them for the K visa interviews. You'll be speaking to an attorney and not some secretary or receptionist giving you legal advice. You will talk directly to a licensed and qualified attorney of the firm, and not someone working out of their garage that does not even have a license to practice immigration law.
Attorney Diza, you've really answered so many of my questions. I want to thank you so much for spending the day with me. So I appreciate it. Thank you so much.
It's my pleasure, Troy. Thank you too.
Thank you.
You can watch previous episodes and sneak peeks of upcoming shows by visiting www.immigrationexperts.tv.
Okay, today I'm with partner and attorney Jeff Kurgel. It's nice to meet you, Jeff.
Pleasure to meet you.
All right, so today we'll be talking about removal of conditional status. Jeff, what exactly does this mean?
What it means is when you get your green card, immigration will only let you keep that green card for 2 years if you've only been married for 2 years.
Okay, so you say 2 years. What if the marriage is maybe a year and a half? Then what happens?
If it's less than 2 years, even if it's only a year and a half, immigration will not allow you to have a full permanent green card. You only get a conditional green card, and you need to remove the conditions on your green card.
Did you know? K1 visa holders can adjust after divorce. K1 fiancé visa holders come to the United States full of hope. They are coming to marry the person they love and are looking forward to establish a family in the United States. Sometimes, the marriage does not work out. since the only way the K-1 can adjust status is through the marriage to the United States petitioner. The fiancé visa holder is left wondering what effect the divorce will have on their immigration status in this country. For a long time, the United States Citizenship and Immigration Services, or USCIS, had held that those who enter the United States on a fiancé visa can only adjust their status to that of permanent resident if their marriage is still intact at the time of the adjustment. Given how long it takes for adjustment applications to be adjudicated in some parts of the country, that can result in many K-1 visa holders being denied adjustment and having to return home. An important immigration decision was just issued by the Ninth Circuit Court of Appeals, which includes California, which held that fiancés who marry their USC petitioner after entering the United States and who subsequently obtain a divorce prior to obtaining permanent resident status are still entitled to adjust to resident status. Although the courts have stepped in, USCIS may continue to deny K visa holders who are otherwise eligible to adjust their status. K visa holders should consult with a trusted and experienced attorney who can ensure your application is treated fairly.
Attorney Flomy Diza discussed some of the common problem areas that usually arise, and these are age differences, financial inability, criminal convictions, medical examination in the foreign country, insignificant proof of the relationship, failure to properly document the application both at the USCIS level and the U.S. Embassy.
If you're planning to immigrate, like Mary Joy, to join her fiancé and get married, then I hope you remembered all the things we discussed today in order to help maximize your chances of success. It pays to be prepared. Today are some of the hardest times in the history of the United States to immigrate or to get a U.S. visa to come to the U.S. That's why it's more important today, more than ever, to be well informed about immigration laws, rights, and opportunities by your immigration experts.
You can watch previous episodes and sneak peeks of up-and-coming shows by visiting www.immigrationexperts.tv.
I'm Troy Montero, and remember to call us for your immigration solutions.
Obtaining a visa at a U.S. embassy or consulate around the world can be difficult or seemingly impossible. High visa refusal rates, complicated waivers, and serious homeland security concerns create an arduous environment for immigrants and temporary visitors to the U.S. R&A's global visa processing team is experienced in working with U.S. embassies and consulates around the world in finding solutions for our clients. The team includes attorneys who have worked abroad at U.S. embassies for the Departments of Homeland Security and State, and who have successfully obtained visas for thousands of clients around the world. R&A's global visa processing team is licensed and available to appear in immigration hearings in all 50 U.S. states and in over 180 U.S. embassies and consulates throughout the world. Further, with modern technology, our team assists clients located in various countries. Our office in Asia and affiliates in 6 continents provide a network capable of understanding a particular case on all sides, from federal immigration and criminal law to local U.S. Embassy operating procedures. Process, technique, and expertise of working with international posts demand both experience and global reach.